The lawyer's microphone's always good. Okay, testing lawyer of the day. Testing podium. Okay, testing Justice Lawrence. Testing Justice Horton. Testing Justice Meade. Testing Justice Connors. Testing Justice Douglas.
It's great to be here at the home of the Blue Devils. We are thrilled and very happy to be joining you for our oral arguments here today. My name is Andrew Mead. I'm the Senior Associate Justice of the Maine Supreme Judicial Court. Ordinarily, our Chief Justice, Valerie Stanfill, would be sitting in this seat and conducting these proceedings, but she has been hit by a bulldozer of a cold or virus and is very sad that she can't be here today, but she sends her best regards to you. She will be participating in all of the cases we're talking about here today because we are live streaming this on the internet and there's also recordings of it, so that will be our full panel. Again, it's great to be here today. The cases that we're going to be processing are real cases. This isn't a skit or some sort of TV courtroom going on. These are real people, real issues of law that we'll be addressing as we do year-round. This is always a pleasure for us to get out and about. I'm joined here by my colleagues on the court. Ordinarily, we have 7 justices of the Maine Supreme Judicial Court. We are down 1 awaiting an appointment, and as I said, the Chief Justice is unable to join us here today. Before we get started, I'd like my colleagues to introduce themselves. We'll go in order, reverse seniority order, as we typically do, and Justice Douglas will lead off with the self-introductions.
Thank you. Good morning, everyone. My name is Wayne Douglas. It's a pleasure to be here. Thank you for having us. I have been a judge for a little over 20 years. I started out on the trial court, and I have been on this court for about a year and a half. And my chambers are in Portland. We don't have one building where we all sit in, but we have chambers or offices throughout the state, and I happen to sit in Portland. Thank you.
Morning, everyone. I'm Associate Justice Rick Lawrence. I have been a member of the judiciary for about 24 years. 22 years were spent on the district court, and I've been on the Supreme Judicial Court for the last 2 years. My chambers are situated in Portland, and very happy to be here, and hope you will all do gain some insight as to how this branch of government works during the course of today's proceedings.
I am Catherine Connors, and I am the only one of any of the justices who was never a trial judge, and I've been on the appellate court here since February 2020. Before that, I was in private practice. I'm from York, and my chamber is in Portland.
Morning, everyone. My name is Andrew Horton, and I have been a judge since 1999, long time, and I've been on this court for about 4.5 years. I came on in February of 2020, and before that I worked in the trial courts, and before that I practiced law with a law firm. And as you can see, we're sitting up here in order of seniority. Justice Connors and I have been on this court longer than Justice Lawrence and Justice Douglas, and Justice Mead has been on the longest. So as you stay on the court, you move toward the middle of the seating arrangement. I was sworn in actually 15 minutes after Justice Connors was at the governor's mansion in Augusta, the Blaine House. And under the normal rules, because she was sworn in first, she would be considered senior to me, and she'd be sitting where I am, and I'd be sitting over there. But because I was a judge for 20 years before I came on this court, I was considered to be senior. And anyway, I'm fine with it, but not everybody is. So anyway.
So and you're moving closer to the middle all the time.
Yeah.
One step at a time. All right, well, now you've met my colleagues. As I said, my name is Andrew Mead. I've been a judge for 34 years, the last 18 of which have been on the Maine Supreme Court. I want to acknowledge some important folks who are here today joining us. If you are present, would you kindly stand and give us a wave to confirm that? The first of which, unfortunately, can't join us here today. Senator Peggy Rotundo is back doing her job back at the legislature. They're swearing in some new judges, so we said we fully understand and pleased to Thank you for that, and also we thank her for the invitation to be joining you here today. We have some other legislators joining us here today. Representative Margaret Craven, she's giving us a wave down front, and Representative Mana Abdi, giving us a wave also. I also want to acknowledge and thank Jonathan Radke, the principal, if he is here, where he's attending to his duties as he should be. Also recognize Representative Adam Lee, who is a member of the legislature, and he is the lawyer of the day. He's going to be helping walk you through what's going on here with us. We thank you very much for that, Representative. I also want to thank the coordinating faculty, including Doug Dumont, the assistant principal, Jeff Burkhart, SRO, and Jason Fuller of the athletic department. We also want to give a nod to the custodial staff and the folks who helped with the AV setup, absolutely critical to what we're doing here today. Also, I want to recognize, going too fast here, Representative Kristen Cloutier is present. Thank you. Also want to acknowledge and thank the Blue Devils football team who actually set up the chairs here. Absolutely perfect, impeccable detail. If they're executing all their plays with that level of detail, you're in great shape. So, we're going to get started in just a moment here today. We are an appeals court. We don't hear trials. A lot of us were trial lawyers and trial judges before we got here. But if someone has a case in the court and it doesn't come out the way that they had hoped, they have the right to appeal that result up to us. They have the burden of demonstrating to us that something went wrong, the law or the facts down below. And if we're satisfied they've sustained that burden of proof, we can vacate, meaning we can sort of wipe the slate clean and send it back down or make some corrections in what happened there. This is not Judge Judy. This is important stuff. We are the court of last resort. It's very important we get it right, which is why there are 7 of us who make the decision, because with a very small exception of cases that can go to the United States Supreme Court, we are the end of the road. So this is very important business here, and is very important to the parties concerned. So, with that said, I think I've covered all the preliminaries. We're ready to get started with our first case on the docket today, which bears docket number Penobscot 24-36, State of Maine versus Richard Kelly. The matter is on appeal here today. I'm going to ask the attorneys who will be arguing if you would kindly stand in place and give us your name and the party you represent. First for the appellant.
Good morning, Your Honors. Hunter Tavares. I'm representing the appellant, Richard Kelly.
Thank you, Attorney Tavares. And for the state?
Assistant Attorney General Katie Sibley, Kelly, State of Maine.
Thank you, Attorney Sibley. We are ready to get underway, and Attorney Tavares would be happy to hear you on your appeal on behalf of your client.
Well, thank you, Your Honor. Good morning again. Let me just take a moment to set the stage about what happened and what we're deciding here. The state got a warrant to track a vehicle, a Dodge, and they got that warrant and they stuck the tracker on the car, which is a GPS tracker, would track everywhere that car traveled. Richard Kelly was a regular passenger in that car. He spent hours, and if you added them up, it would be over days in that car, traveling sometimes 10 hours at a time in that vehicle as a passenger. And everywhere he traveled was being tracked by that warrant. And Mr. Kelly said that he had a privacy interest in his movements in that car as a regular passenger. Moreover, Mr. Kelly also had a special relationship to that car in that he stored his personal property and his work property. He was a fisherman. He had a sea bag that he kept in that car for not just when he traveled in it, the record said for about a month. So he had some other special privilege when it comes to this vehicle. So eventually, based on this warrant, the state got other warrants and they stopped the car and then they searched the car that Mr. Kelly also kept his belongings in, and they found drugs that they want to then use against Mr. Kelly as evidence at the trial. Now, before we got to the trial, Mr. Kelly believed that his rights were violated because the warrants were unconstitutional, which really isn't the issue today, I don't think. But he filed that motion. He wanted the court below, the trial court, to decide that. The state, through the Attorney General's office, after they heard from Mr. Kelly testify about how often he traveled in that car, what his special relationship was to that car, the state said, we agree that he had a privacy interest, so the court should go ahead and decide whether these warrants are valid or not. But the trial court, even though the state didn't ask for it, said that Mr. Kelly can't challenge these warrants because he doesn't have a privacy interest in the car. And we're asking that this court send it back to the trial court to decide whether these warrants were valid or not, because it's not even disputed, and the state agrees that he had a privacy interest in that vehicle, and that's really the right call as well, based on how often he traveled in the car, how we're talking about GPS tracking in his movements, and because he had that special relationship to the car where he essentially used it as a storage facility for his property. So, Your Honor, at this point, I'd welcome questions from the court.
Now, to set the stage here, as we know, if a person has a place, a physical place, in which they have a privacy interest, law enforcement can't intrude in the absence, in this case, of a warrant. Is that correct?
Ask that question again. Maybe I didn't understand it.
Okay. If a person has a place, a house, a garage, a car, and if that person has a privacy interest in that place, the police cannot intrude, at least in this case, without a warrant, correct?
Correct.
So if they do, and if the person believes that warrant, something was wrong with that, they shouldn't have been able to come into my place, they can challenge that in court.
Right.
And that's, in fact, what happened here. But the key to this is that your client must have had a privacy interest in that vehicle. Is that so far so good?
I agree.
The owner of the car probably has a privacy interest because they own it, but he was a passenger in this car. Tell us why just being a passenger in the car would give him a privacy interest that would give him the right to challenge the warrant for the car.
Sure, I can answer that question for Your Honor. It's because Mr. Kelly was more than just a passenger. He was a regular passenger, spent hours in the car traveling. And remember, too, in this case, we're talking about tracking his movements while he's traveling in that car.
Why was he more than just a passenger? He was sitting in the passenger seat, wasn't driving. He was going to a place where the driver was driving. What makes him more than a passenger that would give him the right to challenge the warrant?
Well, the courts said that you have to be more than an occasional passenger. So this isn't as in the Lovett case that the court decided the person didn't have standing as a passenger, where the record seemed to indicate he was a one-time passenger. But I think what really sets this case apart is that he had a special interest in the vehicle, a relationship with it, by storing his personal property. That makes it more like a garage or a storage facility, and the fact that he kept his property in there and had the authority from the owner to do that. So I think that's what separates it from just the pure passenger cases. And remember, the Supreme Court in Jones said that tracking someone's movements is a search. So the fact that we're not just dealing with him driving along the road, stopped for speeding, the car is searched, that would be different, perhaps. Here, the government wants to use all of or the government tracked all of his movements while he's inside the car with a GPS. So that makes it different, too, than the Lovett case or some other cases.
I have two questions for you. One is, was there specific evidence that Mr. Kelly had been a passenger in this car while the tracking device was attached to it?
Yes, I believe his testimony covered the period of time when the tracking device was on the car. So I do believe that's in the record, and it wasn't disputed by the state.
Right, and there's no evidence that the car itself was searched. I'm not sure where Mr. Kelly kept the sea bag, etc., but there was never any search of the vehicle itself during the tracking period, was there?
Well, I believe there was, because the vehicle was stopped while it was still being tracked, and the warrant was executed at that time, and the vehicle was searched in full at that time, and then that's when the drugs were found.
Was Mr. Kelly in the vehicle at that time?
Yes.
When the search was executed?
Yes.
One of the things that you find concerning, if I understand your presentation correctly, is that the trial court ignored the state's concession that your client had demonstrated a privacy interest.
Right, absolutely. I think we shouldn't even be discussing this, frankly, because it wasn't an issue below. The state essentially didn't throw the challenge flag on that, and the court nonetheless took it upon itself to review it. And this court has said in the Maloney case, which I cited in my brief, that on a motion to suppress, which this was, of course, that if the state disputes that the person's rights have been violated, then it's the burden of the defendant to establish it. Here, the state didn't dispute it. They conceded it, and the court even said the stipulations noted at the time.
Well, that leads to my next question then. Is there any contention on your part that your client didn't have a full and fair opportunity to present his case as to why he had a privacy interest?
Perhaps if we knew that the court was skeptical of it or was still going to take it upon itself to decide the issue after the stipulation, perhaps we would have wanted to develop that further and evidence further. But when the state said they're stipulating and the court said stipulation noted, it became, I guess, a surprise that it was addressed and that there was even a motion to reconsider filed on that.
But again, the state's concession came as a result of your client's evidentiary presentation.
Correct, correct.
As you stand here today, are there other facts or circumstances that you feel were not properly addressed or adequately addressed by the court at the hearing?
I think the record is developed enough on this issue and clear enough that standing has been established and that the state was correct in stipulating to it. I do think the court made some, or perhaps the court's reliance on the Lovett case was somewhat misplaced because the court said it could always decide standing, and it actually said in its decision when I reviewed it this morning that in Lovett, standing wasn't disputed, and this court found that there was no standing. Well, but that's actually not accurate. Is in the Lovett case, it was disputed below.
The state disputed it below.
Right. Trial court didn't address it, and then this court addressed it on
but
the appeal.
You have not identified any additional evidence you would have shown in any of the arguments, because the stipulation didn't come until after you had presented your case showing why you thought he had an expectation of privacy. So that's not in the record of any prejudice, because had you known they weren't going to stipulate, they didn't stipulate until the end of the hearing.
On that issue, you're correct, Your Honor. I think that the record from what was established from Mr. Kelly's testimony established the standard.
Okay, let me ask you a question that's somewhat abstruse, and it's going to be the same question I'm asking of the other side, but they get a heads up to think about it.
All right.
There are two constitutions, the Fourth Amendment and Article 1, Section 5, the U.S. Constitution, expectation of privacy protected by the Fourth Amendment. Maine Constitution, Article 1, Section 5, protects it. You alluded to the Maine Constitution, but you didn't develop an independent argument under that. So I want you to assume that we are only entertaining a federal Fourth Amendment argument. Whose standing law do we look at in reviewing a Fourth Amendment standing argument? Do we look at federal law, or do we look at Maine law as to the impact of the stipulation, the scope of the expectation? Which law applies?
Maine law, Your Honor, because this is a Maine case and it's as whether they're standing in the Maine court.
It's a federal claim, though, and wouldn't the federal Constitution govern the scope of the expectation of privacy in order to make a standing claim under the federal Constitution? It's a hard question.
Certainly the court can look at both, right? And I think under either standard that the standing has been met here. But because we're talking about a Maine court and whether essentially the doors of the courtroom are open for this person, the court could look to Maine law as to whether they're standing in this case as well.
And the Lovett case did cite the
I'm
raucous.
sorry, it's just hard for me to hear in here with, maybe I'm getting older, it's just the acoustics.
No, it's not,
Yeah.
it's not you, it's
Okay.
probably me. The Lovett case did cite to federal authority as well. It cited the Raucous case for the
Right.
proposition that the defendant has to have a possessory interest in the car.
Right, and you can decide it under that standard, and this is completely different than the Lovett case for a number of reasons, but particularly because
Well,
of
what-
the
what's the
storage of the
what's
property.
So the two reasons that you think it's different is, one, he had a sea bag, he had some personal item in the car, and two, he rode in the car more often. Are those the two salient facts?
And third, that there was the GPS search throughout of the tracking. It wasn't that this was just a search at the time of the stop, which would have been in Lovett. And it's more than just having the sea bag in the car at the time he was driving. Remember, the record says that Mr. Kelly kept the sea bag in there for, I believe it says, approximately a month. So this is more like storing property long-term than just, having his backpack with him when he's traveling one time in the car.
Was anything discovered?
Yeah.
Was anything discovered in the bag?
No.
And I see the red light is on, so that completes your time in Central, but we will be hearing again from you on rebuttal shortly.
All right, thanks, Your Honors.
Thank you. And Attorney Sibley, we'd be happy to hear you on behalf of the state of Maine.
Thank you, Justice Meade. Your Honors, may it please the Court. The primary issue before this Court today is, as identified, whether Mr. Kelly has a reasonable expectation of privacy and thus standing to challenge the search of Keith Wedge's Dodge Charger on February 22nd, 2021, which resulted in the seizure of a Class A amount of fentanyl powder. The U.S. Supreme Court, the First Circuit, and this Court have repeatedly held that a mere passenger who has no possessory interest in a motor vehicle itself has no reasonable expectation of privacy and thus no standing to challenge a search of that vehicle. Here, Mr. Kelly has no reasonable expectation of privacy in Mr. Wedge's vehicle. He asserted no ownership interest in that Charger, and in fact, he never had even driven it. And contrary to his assertions, a handful of trips, even a few to Massachusetts, and storing a small bag of clothes in that Charger for a period of time is neither equivalent to borrowing a motor vehicle from its owner, nor is it sufficient to establish a possessory interest in the Charger itself. And even though the state was wrong that the evidence presented at the hearing supported standing, the state's error did not prevent the trial court, and it does not prevent this court from affirming the trial court's decision on the correct basis, which is that Mr. Kelly has no standing. I'm happy to take questions at this time.
Obviously, the first question any court asks in any proceeding is whether or not the person before the court has the authority, has the standing to make the point they're making. And here the court below said, nope, he doesn't have standing, so that kind of closes the door on the rest of things. I know we'll want to talk about that, but I want to jump ahead to what he would argue if he actually was going to argue the case. Can I ask you some questions about that? About the warrants themselves?
Yes, Your Honor.
Okay. Now, the warrants here are kind of unique because these were warrants to put a tracking device on a car so the police could see where the car was going from place to place. And if Mr. Kelly has the opportunity, he would challenge that and say, no, that warrant was improperly given because there wasn't probable cause. So if the judge agreed with that this warrant, no good, throws it out, it looks on the face of it that there was actually other evidence that had nothing to do with the warrants. For instance, the state knew of some people who dealt with Mr. Kelly, said he's selling drugs, I bought drugs in the past. And in fact, there were apparently 2 actual buys that the state was supervising there. Does it make any difference to the state whether this, we're getting way ahead of ourselves here, but if it comes to this and the judge says to you, does it make any difference whether this warrant stands or falls because you've got 2 buys that would be admissible in evidence?
Well, the 2 buys were with Mr. Wedge, not Mr. Kelly. So the warrants are important here in the sense that they lead to the motor vehicle stop where Mr. Kelly is the mere passenger in the Charger with Mr. Wedge, who are the targets of the actual investigation.
That's right. I'm sorry. The actual driver was apparently engaged in drug trafficking, and it was very clear regarding him, so that would support the warrant. Was there evidence regarding Mr. Kelly that would support a conviction separate and apart from what they learned from these warrants?
Not that I am aware of and not that I believe is in the record before the court.
So it makes a big difference whether these warrants stand or fall?
Correct.
Okay. All right, we can circle back to the issue of standing, and I'm guessing my colleagues will have some questions on those.
Actually, I'd like to take up the warrants a little further. Is there an issue with respect to the tracking warrants to the in terms of them being in violation of 639 sub 4, to the extent that they were tracking the vehicle when it was outside the state of Maine?
That statute does allow that. The most important thing is that the tracker needs to be installed within the jurisdiction of Maine. There is no evidence that this tracker was installed outside the jurisdiction and thus in violation of the warrant.
I have a question about the stipulation, and for everyone's benefit, a stipulation is an agreement, and it's very often during a trial, the attorneys for the people involved in the trial will say to the judge, we stipulate, meaning we agree on something. And here, the state's attorneys told the court that the state agreed that Mr. Kelly had standing. In other words, that he had the right to contest the warrant and argue that the search was illegal. And these stipulations happen all the time. The court doesn't have to accept a stipulation. The court doesn't have to, even if an agreement is presented, the court doesn't have to accept it. But here the court said stipulation noted, which sounds like the court was accepting the stipulation. And I guess I'm concerned about precedent we would set if we said a stipulation that appeared to be accepted by the court wasn't binding. That's question one. Question two is, if we say that the stipulation was binding and therefore the court should have agreed that Mr. Kelly had standing and gone on to address whether the warrants were valid or not, should we decide ourselves based on the evidence presented, whether the warrants were valid or not? Or should we, as Mr. Kelly, I think, is asking, send it back to the trial court for the trial court to decide whether the warrants were valid?
As to the first question, Your Honor, I believe the trial court statement can reasonably be interpreted as just noting that the stipulation was part of the record and not necessarily, I accept this stipulation as fact. Even still, standing is a threshold question for all of the courts, and just as this court didn't love it because neither of the parties had argued it, the trial court hadn't brought it up, and I believe in Blanchard as well, even though that wasn't a criminal case, brought up standing sua sponte because it is that threshold question. So even though the state erroneously agreed, it was important for the trial court. It was the trial court's duty to independently assess whether the evidence was sufficient to establish standing. And this court can do the same. This court, I believe, pointed out in both cases, is not bound by the trial court's determination.
It seems to me there's two possibilities would happen when there's a stipulation. As Justice Horton pointed out, stipulation means handshake. We agree that the defense and prosecution agree to something. Now, if, let's say in a trial that the state, the defendant agreed to something, so the state or the defendant figures, okay, I don't have to bother with that because they've already agreed to it. So I have great evidence, but I don't need to put it on because it's already agreed upon. Then it comes down to crunch time, verdict time. The state says, we withdraw our stipulation, don't agree. And the defense says, wait a minute, I had a great case and I didn't put it on because we agreed. That would be one situation. Situation two would be where the parties enter into a stipulation, but the evidence has already gone into the record. And the state says, oh, okay, now that I hear everything you've said, I agree to it now. Do you agree that in the first case, that would be an injustice to require the defendant to roll over and without the evidence? But in the second instance, the defendant would have had an opportunity to put the evidence on, even though the state ultimately agreed. Is that a valid distinction between the two?
Yes, it is, Your Honor. I would completely agree in the first instance that would be an injustice. That's not what occurred here. What occurred here was that the evidence had already been presented, and this, to the state, isn't an issue of whether the state waived its argument. Waiver expressly, it applies when a party expressly waives and then fails to prevail at the trial court level.
So you say there's no prejudice here to defend that they put the evidence on. Mr. Tavares may disagree, but your point is they did have an opportunity to put the evidence on.
They put all of their evidence on to show it before the state erroneously agreed that that was sufficient.
And now you're arguing to the contrary here. You said I agree to this, but now I'm defending the judge's decision that there is no standing. Is that uncomfortable?
It is, especially when I was not the attorney
okay.
below.
All right, we'll move on then. Okay.
So let's get to my question that you now had time to think about. Is the standing issue, when it has to do with the expectation of privacy, is that a state law question or a federal question when it's a Fourth Amendment issue?
Well, in this case, it's a strictly federal claim because an argument under the Maine Constitution was not developed properly,
Right.
either at the trial court or here.
But do we apply the federal rules about standing? Or, I mean, you said this is a threshold issue. We can raise it sua sponte. The state law to get into court standing is different in state court. It's prudential standing in Maine, while it's Article 3 and there's jurisdictional standing there. But it's also a component of the expectation of privacy, which is the claim itself. So it's not really the threshold standing issue, which sounds more like state law to me. It sounds like it's more a component of the federal one. And if it is a component of the underlying claim, then does a stipulation have a different weight and you don't raise it sua sponte and it's a question of party presentation?
I believe it in either circumstance, even in the federal interpretation, standing is still a threshold issue that that federal courts address well. So even though this court is addressing a purely federal claim, standing is still something that should be, that the trial court properly considered and that this court should consider as well. As far as the law going forward to apply, as this court has done before when it has strictly federal claims, is to look at the federal law and even still look at Maine law. For instance, in the Lovett case, in ruling that there was no standing, there was no reasonable expectation of privacy, this court relied on the U.S. Supreme Court decision in Rockus versus Illinois.
So what would have happened if he was homeless and he was living in that car? Would that make a difference?
It could potentially, Your Honor. There may be a different type of possessory interest. What we have here is, I believe, testimony that he traveled about 5 times in the vehicle over the course of a few months. Went to Massachusetts on a few trips, but the First Circuit in the Simonovich, I hope I'm pronouncing that correctly, case said duration may matter, but they found the trips from Maine to Massachusetts not sufficient, and the small bag of clothing. This wasn't a situation where Mr. Wedge allowed him to live in it, where everything that he had was contained within that vehicle. What
if they had searched the bag? Does he have an expectation of privacy in the bag in the car?
Well, if it is his, in some ways, yes, but in the Simonovich case, the defendant in that case said that the tire inflator can that was underneath the passenger seat, that belonged to him, and the First Circuit said, yeah, but it was in the vehicle under the passenger seat where you didn't have a reasonable expectation of privacy. Also in this case, there was a warrant to search the actual vehicle for certain items, and if items that were allowed to be seized under that warrant could have been concealed within that bag, then under the warrant they would have been able to search as well.
Yes, but he might have standing, wouldn't he? If he has a possessory interest in the bag.
he could, but what's at issue in this case is the search of the whole vehicle, not the bag.
What about the trunk, where he keeps the bag? And what I'm understanding is that he stored it there for a long period of time, or for some period of time. He's going in and out of the trunk. Does he have an expectation of privacy in the trunk?
I believe the testimony was that the bag remained in there for about a month or something like that. I don't recall if the bag was actually in the trunk, but it's really good timing. Again, in this circumstance, Mr. Kelly had no possessory interest in the entirety of that vehicle.
Understood, but this is different than Lovett, because in Lovett there was no evidence at all here of any kind of possessory or other connection to the vehicle. But here there is additional evidence, which we've been talking about.
I would argue it's not that much
Not
additional
enough.
evidence. It would be it would be akin to if I rode in a friend's vehicle and I happened to leave a bag in there and then I forgot about it and remembered. I now have a possessory interest in the vehicle. I think that's too far of an extension that both the Supreme Court and this court have taken the reasonable expectation of privacy and what a possessory interest for a mere passenger means.
Well, I'd ask opposing counsel if anything was found in the bag. And in this circumstance, do you know if the bag was searched?
May I answer, Your Honor? I do not recall off the top of my head. I would think, just based on my general experience with these, that law enforcement likely searched the bag.
Thank you.
Thank you.
And Attorney Tavares, you have the burden, so you have the last word in rebuttal.
So when we're talking about a reasonable expectation of privacy, the question really is, does anyone really think that when they're traveling around in a car for hours, that the government is tracking where they're going, knows where they're going every minute of the trip? And if someone is going to leave leave some property in the car, and they are going to keep it there. So I'm glad I got one too.
You got one too.
And
Okay.
if they're going to keep it there, do they really think the police are just going to be free to go and search that car? They don't have some privacy interest in the place they're storing their property. And I don't think the law that's what the law means. And all the cases the state cited are all different than this case. They don't have the facts that we have in this case.
But I guess I'm missing the connection. Because the car was being tracked, why does that create a reasonable expectation of privacy on behalf of your client?
Because he's a passenger traveling in the car, and the U.S. Supreme Court said in Jones that the tracking of someone's movements in the car, it was a car in that case too, I know it was the driver, but it said in that case that the tracking itself is a search. So they said that's a search. So that's a search, just the tracking alone, not
Okay.
even
But he has no ownership interest, correct?
he doesn't own the car. Right.
Doesn't even drive the car.
Right.
He's simply a passenger in the car on a number of occasions.
Right.
Some of those occasions, there was a tracker that was keeping track of the whereabouts of the vehicle.
For months, right. Right. And as far as your question earlier about if the court should decide this on the merits of the rest of the motion, I would suggest it's premature to do that because the court below didn't make factual findings, didn't make conclusions of law, and there was an open question the court never decided. There was a motion to reopen filed as to whether the warrant was also defective because it was issued for 60 days when the statute says it can only be issued for 30 days. So if you find standing, it should be decided by the trial court before you take a look at it.
Thank you.
Thank you.
All right, that concludes our oral argument in this matter. We'll take the matter under advisement and issue a decision in due course. So you may be wondering what the heck does that mean? Because you want to know, does Mr. Kelly have a privacy interest in this vehicle that would give him the right to challenge the warrant? I made a good point too, to challenge the warrant. And that's a big deal because it concerns whether this prosecution goes or doesn't go. What happens next is that the six of us, including the chief, will gather and we will confer on this. We'll lock the door behind us and debate with each other. We may have different positions on it. If we all agree on the result, we issue what's called a unanimous decision. Six of us sign on Sometimes some of us disagree with the position the other has taken. In that case, the majority prevails. The majority opinion carries the day, but the ones who disagree can write something called a dissent, where they say, I think you're wrong about that, and this is why. That's the next steps in this matter. I think at this point here, Counsel, if you're willing to stick around for a little while, just in case there's any questions from anybody who attended here today, and Attorney Lee will facilitate that process there. So I think that covers it all. So again, thank you very much. Pleasure to be here, and court will be in recess.
to establish that you have a reasonable expectation of privacy, you then go to the next level of, was there probable cause to justify the warrant? Yes? Where is Mr. Kelly today?
He's not here, but he's he's not in jail either, though. He's probably he's living at home still while this is on appeal. Yeah. On bail, so yes, he's able to stay out on bail while the case is being decided. I do, but I really don't remember. It was in the thousands of dollars. Yeah.
Yes?
I can't hear you.
Stand up and yell. Good question.
If they can use the evidence, the amount of drugs would matter. But as to whether the warrant was good or not, the amount of drugs doesn't matter because the judge just looks to see if they had a reason to get the warrant to start with.
So I think this is an aggravated drug trafficking case, right? So
Yeah.
that means how many drugs? Yep.
Yeah, sure. So there was a question following up about your bail question issue. While someone's on bail, there are certain conditions. They can't just do whatever they want. There could be a curfew. The police could check if there's a reason to think the person might be violating the law to make sure they're not. So there are some restrictions on liberty. Well, can't leave the state of Maine. Well, there's no evidence of that. And really our position all along was that it was the driver that was trafficking drugs. And yeah, the whole case was about the driver, really. They thought he was the drug trafficker, but then
but she sends her best regards, and she will be involved in the ultimate decision-making in all of these cases because she's either listening to the live stream or will be listening to the recording after the fact. So ordinarily there are 7 of us on this court, but we have a vacancy right now, so we're down to 6. And of course, the chief isn't here today. But at this time, we're going to have our colleagues introduce each other, well, themselves actually, starting with our junior-most justice, that'll be Justice Douglas. If you lead off, please.
Good morning. My name is Wayne Douglas. Thank you for having us here. It's a pleasure to be in Lewiston today. I have been on the bench, mostly on the trial courts, for about 20 years, and I've been on this court for approximately a year and a half. And we sit in different, we all have offices in different places. In this state, the Supreme Court is not in one building, but we do get together, obviously, for arguments. But my chambers or office is in Portland.
And good morning, I'm Associate Justice Rick Lawrence. I'm from Portland. My chambers are in Portland. I have been a member of the judiciary for 24 years, 22 of which were serving on the district court, and I've been on this court since May of 2022. It's a pleasure being here today and seeing everyone here.
And I'm Catherine Connors. I've been on the bench since February 2020. I am from York County, and my chamber is in Portland.
Morning, everyone. My name is Andrew Horton. I've been on this court for about 4.5 years. And before I became a member of this court, I was a trial judge for about 20 years. I became a judge in 1999, and before that I worked at a law firm. And while I was a trial judge, I think this is true also of Justice Lawrence, he and I spent a lot of time here in Lewiston, at the Lewiston court, while we were working as trial judges. And it's great to be back. Thank you for having us here today. We go to high schools every October. We've been at Messalonsky up in Oakland on Tuesday. We were at Deering High School in Portland yesterday, and here we are today. We really look forward to this occasion, and we appreciate your inviting us.
As I said, my name is Andrew Mead. I've been a judge for 34 years, the last 18 of which have been on the Maine Supreme Judicial Court, the law court. My chambers are principally based in Bangor, but we hold forth in Portland and Augusta and Bangor and in the high schools in October. So I want to acknowledge some very important folks who are here today who have made this possible. If you're present, would you please stand or give us a wave? Senator Peggy Rotundo actually was a key player in this, but she is back at the legislature doing the important work they have to do there. Also, Representative Kristen Cloutier is present here. Thank you again for the invitation. We also recognize Representative Margaret Craven and Representative Mana Abdi, who I guess other obligations. Also want to thank Jonathan Radke, principal of the high school here, for making this all possible. Also, special thanks to Representative Adam Lee, who's not only a member of the legislature and the Judiciary Committee, but he is also the lawyer of the day who will help organize things smoothly as they move along. Also want to give a nod to Doug Dumont, the assistant principal, who was the coordinating faculty who made this possible. I'd like to recognize the custodial staff. Thank you for the accommodations. Also the AV folks who set things up. And special thanks to the Blue Devils football team who apparently set up all the chairs here. And as I said before, with that sort of precision, if they're executing their plays with that level of detail, you'll be in good hands altogether. We are an appellate court, which means we don't have trials. When someone has a trial in the courts of the state of Maine and they don't like the result, they can appeal it to us. And if they're appealing it, they have the burden of convincing us that something went wrong down below, a mistake of law, a mistake of fact. We review that. We hear oral argument in many of the cases. And then we, meaning usually it's the 7 of us, but we have a vacancy, but the 6 of us will convene afterward and debate it and issue a decision, which becomes the law of the state of Maine. We'll cover more on that later. but I believe we're ready to get underway with our next case this morning. This is Penobscot, docket number 23-502, State of Maine versus Debbie Anderson. The matter is in order for oral argument. At this time, I'll have the attorneys stand and introduce themselves. First, for the appellant. Good morning, Attorney King, and for the state.
Good morning, Your Honors. Mark Rucci, for the appellee, State of Maine.
Good morning, Attorney Rucci. We are ready to get underway with our oral argument. Attorney King, we would be happy to hear you on behalf of your client.
Good morning. May it please the court. Michelle King for Debbie Anderson.
Yeah.
Let me start over.
Oh, better. Okay.
Thank you.
Yep. That's
Good morning, and may it please the court. Michelle King for Debbie Anderson. Ms. Anderson was convicted of OUI drugs on September 21st, 2023. She was sentenced to a mandatory 7-day jail term as a second offender. She lost her license for 3 years, and she was assessed a $700 fine. Her sentence has been stayed pending this appeal. Approximately 2 weeks after her conviction, her trial attorney filed a motion to dismiss pursuant to 17A MRS Section 12, also known as the de minimis statute. That motion was denied. Before I launch into my argument, I need to correct an error in my brief. On page 14, I made the statement that Ms. Anderson was not asked how she felt while driving. That's an incorrect statement, and I apologize for that oversight. She was asked, however, it was her answer that was somewhat unclear. That being said, prosecutorial discretion is an important part of our judicial system, but it's also important to have checks and balances. The de minimis statute provides such an important check on prosecutorial discretion. Its purpose is to provide flexibility in the administration of justice. When faced with the opportunity to apply the factors set forth by this court in Carger, the trial judge, as the state concedes, did not fully address these factors. The state argues, however, that this court is not in a position to assess those factors because the lower court failed to do so and because the state had no opportunity to answer the newly submitted evidence. As the trial court noted, however, the state declined to respond to the motion to dismiss, and therefore the state had the opportunity, they just declined to take it. Further, that the trial court failed to address the Carger factors does not equate to a lack of evidence before that court to do so. There was sufficient evidence before the lower court.
I see the green light's on, so why don't we jump right into it? As we know, the state of Maine's operating under the influence laws are very literally strict. It's a strict liability statute. And a person is guilty of operating under the influence if they operate a motor vehicle while their mental or physical capacities are affected to any extent or to any degree. Do you agree with that statement?
Yes, Your Honor, I do.
I hope you do, because that's the instruction we give in every trial that comes before us. So
I'm with you so far.
Okay, all right. So it's a very strict law, and in this instance here, as you know the facts, I'll just recite them, but your client takes a number of medications, and I think she listed 11 that she had taken at the time, and she was driving, and she felt her head was getting kind of fuzzy, hazy at some point, and she was headed from one location to a convenience store to use the restroom there. So she gets to the convenience store, and the clerk inside noticed that she parked rather oddly. I think you said her vehicle pulled 3/4 of the way into the parking space, but looking at it here, it's barely into the actual park. Someone would walk by and say, that's an odd way to park there. And the convenience store clerk saw her kind of stagger in, very unsteady to her feet, to the point that the clerk came out and sort of helped her to a counter, and then she ducked into the bathroom. So the clerk called the authorities and said, I think there's a medical event going on here. They came in, and the officer made observations that led him to believe that she was under the influence of something, and she acknowledged that she was taking all these medications. He's a drug recognition specialist and concluded that. So under those facts, do you agree, you probably won't agree, but the state has to prove that she was under the influence while she was operating the motor vehicle. And that's one of your principal points on appeal, that did the state prove that she was under the influence while she was operating?
Yes, Your Honor, that's my second issue, that the state failed to prove that she was impaired while she was operating, correct?
And the evidence against that would be that she did say she was noticing something that was happening, I forget her exact words, fuzzy or...
I believe she said she was lightheaded and her vision was blurry, and then she immediately pulled into the gas station.
And then we have witnesses who observed her physical manifestations there. So it required the trier of fact, a judge or a jury, to say, okay, well, if she's staggering at the point where she walks into the store and she just pulled into the parking place, we would infer that she was under the influence. That, you with me so far on that?
Yes, Your Honor.
Okay. Under the circumstances here, you have tendered what they call a de minimis offense, which means in Latin, I think, of little. And the idea is that, well, she may have been under the influence and she may have driven, but it was so minimal that the judge really shouldn't accept that as a defense to this case. Just looking at the facts I just indicated here, they don't seem on their face to be that level of, I mean, de minimis basically says they did something, but that really wasn't the evil that the statute's intended to prevent, but if she operated under the influence, that is the evil the state intended to prevent. So I've taken up a lot of your time here. I'm going to hand off to you, and you can respond to the questions I've posed here.
Yes, Your Honor. I would submit to you, or to all of you, that under the statute, in either subsection B or subsection C, the motion to dismiss should have been granted. Subsection B actually provides whether or not the defendant actually caused or threatened to harm the cause prevented by the underlying statute, in other words, the OUI statute, to an extent that was so trivial. And as you've noted, the evidence in this case was that, well, actually, let me back up. The evidence in this case was that on the morning of this incident, Ms. Anderson had taken her medications that were prescribed to her by her doctor in the exact fashion prescribed to her by her doctor. She said that she took her friend to the police station and that during the course of the morning, she felt completely fine from her medications. At some point while she was waiting in her car at the police station, she had to use the restroom, but she knew she couldn't do that at the police station because there were a number of stairs that she couldn't take, and she had a very bad back and had a number of back surgeries. So she decided to drive her car over to a gas station where she could use the restroom. She said all that morning she had felt fine, but as she was pulling into the gas station, she had blurry vision and felt lightheaded. It was at that point that she pulled into the parking spot. Halfway, 3/4 of the way, it's a little bit hard to tell from that picture, but certainly not fully all the way in. She walked into the gas station, and at that point, her gait was off, as noticed by the clerk. Ms. Anderson testified that this was due to the number of back surgeries that she had, and in fact, the officer testified that he couldn't rule that out as a possibility for her unsteady gait.
Well, your de minimis argument hinges entirely on the defendant's testimony. In other words, that she felt fine until immediately pulling into the gas station. Was the jury required to believe your defendant's testimony?
Well, the jury is required to look at the evidence, Your Honor, and there was no evidence to the contrary. There was no evidence of impaired operation prior to her turning into the gas station whatsoever. So while the jury didn't have to believe her, they couldn't make up evidence of impairment as she was driving down the road before she pulled in there.
You agree that there is evidence of operation. Pulling into the parking space is operating a motor vehicle, correct?
There is absolutely evidence of operation, Your Honor, 100%. What I'm saying is there was no evidence that as she was driving from the police...
How long she'd been operating while impaired?
The testimony was that the gas station was just down the street from the police department. I don't believe that there was any testimony as to 1 mile or half a mile, but the testimony came out that it was just down the street.
Counsel, I hear your argument that your point is that there's no direct evidence that Ms. Anderson was operating impaired. There is evidence that when she pulled into the gas station and attempted to park the car, she did that in a haphazard or odd or incomplete way. When juries are instructed at the end of a trial, they're instructed on both direct and circumstantial evidence, and on that they are permitted to make reasonable inferences from facts that have already been proven beyond a reasonable doubt. Isn't that what the jury did here? So didn't the jury, as a matter of fact, make a finding that Ms. Anderson operated while impaired?
Certainly, Your Honor, in convicting the defendant, the jury must have come to that conclusion.
Okay,
If
so
we're
then-
looking, I'm sorry.
Then I want to go to factor B, which is did not actually cause or threaten the harm to be prevented. The harm to be prevented by this law is to prohibit and discourage people from driving while impaired. How do you reconcile what the jury found and what you're arguing here today, namely that that factor B is a basis for a de minimis ruling?
Yes, Your Honor. I would argue that the danger to society, to drivers as whole, is the purpose of the OUI statute. In other words, having people who are driving while impaired on the road, the danger that causes is the harm that the statute was enacted to address. In this case, there was certainly no actual harm. Ms. Anderson didn't hit another car. She didn't drive herself off the road. She didn't drive in a manner, at least there's no evidence of, she didn't drive in a manner that swerved at another car, that perhaps swerved at a pedestrian. So I would argue that in this case, there was no actual harm or no threat of harm, and any threat whatsoever was so trivial, so minor in this time period in which Ms. Anderson was driving from the police station to the gas station. And the trial judge, in addressing this, seemed to address the timing factor, how long or how far she had to go. And I would suggest to you that that issue is important as to whether it's trivial or not, but it's not relevant as to whether or not the underlying statute was, there was a proper violation. In other words, when you look at the trial judge's decision, he didn't properly address whether or not such a short period of time on this case, in this case, was trivial.
Well, your argument would be quite a bit stronger if Ms. Anderson had been found pulled to the side of the road, as opposed to driving to a destination and attempting to park, wouldn't it?
Well, Your Honor, no, not in this circumstance, because again, if we believe Ms. Anderson, and we have no evidence otherwise, Ms. Anderson said she began to have blurry vision and felt lightheaded as she was pulling into the gas station. So when she got into the gas station, that's when she pulled over. If she would have said she had those symptoms just as she left the police department within 100 yards, I may agree with you. But in this case, she said she pulled in as she was pulling in.
But again,
you're
you're hanging that on your client's testimony. I mean, she was found guilty of operating under the influence, which means that the court found she was operating a vehicle while she was under the influence. Operating a vehicle while under the influence is the hazard that the statute is intended to prevent. So if a person is impaired to any degree, they're operating on the road, that's the hazard, and it's not de minimis. How can we say it's de minimis? That's exactly what the legislature had in mind.
Well, Your Honor, and again, we have to look at this at a case-by-case basis, and I'm not sure what else Ms. Anderson could have done in this circumstance. As soon as she started feeling ill, she pulled into a parking spot. And I don't think we want to encourage...
I don't mean to interrupt, but we're running short on time. So at a certain point, according to what you're saying, we take it at face value, she realized something's going on, and she pulled in almost immediately thereafter. I just want to make clear, in case anybody's listening out there, the fact that a person's on a prescription medication is not a carte blanche to drive. If you're under the influence of a prescription medication, you're violating the law if you operate a motor vehicle. And also, we did have a case, I can't recall the name, maybe the state's attorney can remember it, but a gentleman had a prescription for medication. He drove, he didn't feel that he was under the influence. He may have been influenced by the fact that he had the medication, but he committed the offense of operating under the influence. So I'm just circling back to your point that she didn't feel, that she was under the influence except for this hazy feeling, but there's a court finding that she was under the influence while she operated. How do we reverse engineer that into a de minimis defense?
Well, Your Honor, I would like to address the Curtis case because that case is quite different than this case. And in that case, the defendant admitted that there was a warning label on his prescription drugs that he shouldn't operate a car while taking the drugs. In this case, Ms. Anderson followed completely her doctor's orders to increase her medication. And
she was taking a narcotic. She was taking Vicodin. She'd been taking Vicodin for years, which is a narcotic. Benadryl, which is makes you go to sleep. And was it Ambien? No. What was the medication she had here? Abilify.
Abilify was the new one, Your Honor, and she testified that her doctor had told her to gradually increase her doses, which she had exactly done. And she testified that morning that she felt perfectly fine. She had every reasonable belief to believe that she was going to be fine driving.
And I'm going to exercise my prerogative as acting Chief Justice. I cut you off as you were talking about the Curtis case and why we should treat this as a de minimis.
Oh, yes, Your Honor. In the Curtis case, as I was saying, that defendant admitted at trial that his prescription bottles had a warning label that said, do not operate a car while taking these. In this case, Ms. Anderson, again, followed her doctor's orders to the T. She gradually increased the Abilify, which she had started, she was on her third day, on the day of this. And there was no evidence whatsoever that came in that she was, for any of the medications that she was taking, that she was cautioned that she shouldn't drive. And in fact, as you noted, she was on Vicodin for a number of years, and she said she had never had any ill effects or had never felt drowsy having taken any of her prescription drugs previously.
All right, and you have waived rebuttals, so thank you for your argument
That's
here
it
today.
from me. Thank you.
Okay. Attorney Rucci, we'd be happy to hear you on behalf of the state.
Acting Chief Justice, and may it please the court. The principal aims of the de minimis statute as relevant in this case are twofold. To shield from the condemnation of conviction those individuals who violate the law in such a trivial way that to saddle them with a conviction works an injustice in that case. And as in Cargar, to dismiss prosecution where admittedly criminal conduct occurs in a context which the legislature could not have envisioned in defining the crime at issue. Here, Ms. Anderson, an individual with one previous OUI conviction already on her record, took a full dose of a new medication and several other medications as administered by her partner while on notice from her doctor that she should slowly ramp up the ingestion of the new medication in order to see how it affected her. That, in this case, the effect was adverse to her motor and cognitive functions, and she got behind the wheel of a car. The evidence shows that she operated on a way while her mental or physical faculties were significantly impaired, putting other travelers in danger and exemplifying exactly the type of conduct that the legislature sought to criminalize in enacting a statute with no mens rea requirement. The risk to which Ms. Anderson, subjected others in the case was not trivial, and the facts are not so aberrant that they defy legislative consideration. The judge did not abuse his discretion in denying the motion to dismiss, and the conviction of the trial court should be affirmed. And at that point, I would open the floor for questions.
You mentioned de minimis. That's a defense that is often tendered and seldom successful, although my colleague to the right, I think, has like the leading case on de minimis in the state, so I'll let her talk to that later. But in this case here, if in fact we accepted Ms. Anderson's statement that I really didn't feel anything until after I parked there, isn't the element of operation missing, if we accept her testimony?
No, because operation is defined extraordinarily broadly under the state law. And I'm not even sure I correctly heard your question. I'm having some trouble. But I think what you asked was can I prove operation in this case?
Yes, yeah, that's
operation is defined as operation or any attempt to operate. So under Maine law, I mean, operation here is, I would respectfully suggest to the court, not at issue.
So here's the hypothetical, the dreaded hypothetical. Not that dreaded.
That's an ominous sound because the dreaded hypothetical is. All right, now with that.
Okay? Just one at a time, I guess.
One at
from
a
now
time.
on. All right. So, dreaded hypothetical.
Sure.
So the answer is not, that is not this case. So, what if, as is being argued, but stripping it of some of its facts, you are taking a drug that you've been taking for a long time, and it works perfectly fine, you drive, no problem. You're driving along, and all of a sudden you get double vision. You immediately go to the side of the road. Is that a case that is ripe for de minimis?
It would depend on other factors that the court outlined in Kargar as taken from the Model Penal Code and as taken from Hawaii precedent. But on those facts, I mean, I would think consideration of the defendant's criminal history would be important. A number of factors which might need to be determined at a testimonial hearing that are relevant under the Kargar analysis. But potentially, yes. I would agree with you, Your Honor, that seems to be...
Okay, so she's saying that what I just outlined was the situation. So what are and you said we have to look at context. So what are the added facts in this case that say it's not subject to the broad discretion for de minimis application?
Sure. The added facts in this case, when we look at the purposes of the de minimis statute, the background and experience and character of the defendant is important. This was someone with a previous OUI conviction. Knowledge of the consequences to be incurred. She would have incurred some version of those consequences prior, despite the fact that there is a prior alleged it's the same exact class of crime. It's subject to different mandatory minimums, of course. Circumstances surrounding the conduct, I would suggest that just because the jury heard that the defendant felt dizzy for the first time right as she was entering this parking lot, they didn't need to accept that testimony in light of the other evidence that was in the case that she could barely, frankly, stand up by the time she got into the gas station. They could have rejected that testimony and said, we thought she was likely feeling it earlier while she was on the roadway.
Well, what's the evidence, now we're going to sufficiency, what's the evidence that proves beyond a reasonable doubt that she didn't immediately, as soon as she felt dizzy, that was when she was pulling into the parking lot?
There isn't any evidence that the state offered that would directly contradict that, but just because that's true does not mean that the evidence is insufficient to support a conviction. The truth of the matter here is that she was operating a motor vehicle and was under the influence, impaired however slightly or to any extent by the ingestion of alcohol, or a prescription drug, which is how this court instructs juries, and that is enough to satisfy a conviction in this matter.
I'm going to go a little off topic here today and put you on the spot.
Sure.
A person is driving on a 4-lane highway, and suddenly, as a result of a new medication they received, realizes, wow, boy, something's wrong. I'm feeling the effects of this. I'm feeling fuzzy. My judgment's off. And there is a rest stop just a quarter mile up the road. So this person knows that they're under the influence. They know it's against the law because Maine has a very strict operating under the influence law. Would the competing harms doctrine immunize that person if they stay operating under the influence and hold on to get off the highway so they don't cause, he's in the far left lane too, he's have to cut across the lane of traffic. It's hypothetical, it's policy, you don't have to answer if you're uncomfortable with it, but I'm just wondering whether that would apply.
I would think that it would depend on circumstances that would need to be developed on the record, such as traffic patterns. There may be an instance where it's perfectly safe to pull off to the side of this 4-lane highway and not cause any issues at all. Or it could be the instance that, I'm going to New York right after this with my family, a dog and 4 kids. Maybe I or my wife has that circumstance and thinks, I cannot safely pull over to the side of this 4-lane highway and not risk my family's safety. In that case, maybe there is a colorable competing harms defense. I know Justice Connors told me not to say this during her hypothetical, but that is not this case.
Absolutely not. And for those in the audience here, you just heard a very astute and very appropriate answer. It's 2 words, and it will serve you well as a lawyer if you go into law. It depends, right? It does depend, and that's a fair answer and appropriate answer.
And
further questions?
Well, bringing you back.
Back to reality.
Bringing you back to this case, wasn't there evidence that reflected that when confronted by law enforcement, the defendant indicated that she thought the medication had affected her, correct?
I think she said she was a 9.
Well, I was going to get to that.
There
First,
was
she
a-
just said it affected her, and then asked on a scale of 1 to 10, what did she indicate?
Yes.
That
She said it affected her, and then she said she was a 9, and there was some back and forth, but Lieutenant Benjamin asked her, when you were driving, how were you feeling? And she, irrespective of the fact that she later said she felt that it had to do with dehydration or a medical event, she admitted at the time that she felt impaired.
And couldn't the jury infer from the way the car was parked with the other evidence that came in that, in fact, she was impaired while she was operating the motor vehicle?
Yes, and I would say, that the evidence the jury had before it the picture that Justice Meade held up to Attorney King during her opportunity to argue, and that, to the state's eye, is colorable evidence that this person was operating in a manner that was inconsistent with someone who was not impaired.
And do I recall correctly that the evidence suggested at one point she indicated that she was feeling better and was going to drive home, but the Sergeant Benjamin had to prevent her from doing that?
If I heard your question correctly, I do believe at one point she said, "I'm feeling much better now," and in fact, EMS came and checked her out and determined that this was not a medical event that required transportation to an emergency care facility. And that at that point, that is when Lieutenant Benjamin continued with his evaluation, with his roadside investigation, which really occurred in a parking lot. And if there are no further questions, I'll rest on my briefs.
That appears to be the case. Thank you, Attorney Rucci. And rebuttal has been waived, so that concludes our oral argument. We do thank the attorneys for their briefs and oral argument here today. We'll take the matter under advisement and issue a decision in due course. What that means, you'd probably like to know right now whether or not we're going to sustain or overturn this operating under the influence conviction. But the 6 of us will gather in our chambers and we will debate it amongst ourselves, share our opinions, and eventually issue a written decision. If everyone agrees with that particular decision, that's called a unanimous decision. But occasionally, some of us may disagree and feel that the approach is slightly different, and they may issue a dissenting opinion. The majority still governs the day, but a dissent sometimes will signal that the law might be uncertain, which I see a bunch of folks from the case coming up later. We may hear that again here today. But a dissenting opinion allows the judge to say, we don't sign on to what the rest of them are saying, but the majority still controls the case. So again, thank you for your attention here today. If there's nothing further, we'll take the matter under advisement and court will be in recess. Fill the halls. And welcome to folks watching online. We're streaming this live online. My name is Andrew Mead. I'm the Senior Associate Justice of the Maine Supreme Judicial Court. Ordinarily, Chief Justice Stanfill would be seated here and conducting these proceedings, presiding over them, but she has, as I've been saying, been hit by a bulldozer of a cold and a virus, but she's very much part of this panel. She'll be participating in the decision process. She's either listening now or will be listening to the recording later. We also have one recusal and a vacancy, so the panel for this case will be us plus the Chief Justice. Want to say a few words before we get underway. First is to welcome the students who are joining us here today. And I have some recognitions I'd like to pass on. This is, for those of you who don't know, this is part of our October, what we call the high school road trip. These are cases that we present at high schools around the state at the invitation of state representatives. I'd like to, if any of these folks are present, if you please just stand or give us a wave. I'd like to recognize Senator Peggy Rotundo. She was one of the key players here. She's actually at the legislature voting on judicial nominations today, so we certainly said to her we understand and support that. Also, Representative Kristen Cloutier was present earlier, but she also had other matters to attend to. Representative Margaret Craven is present, giving us a wave. Representative Mana Abdi, I believe she also had another obligation to attend to. Also want to express our thanks to Jonathan Radke, who is the principal here, for putting this together. We're grateful for that. Special thanks to Representative Adam Lee, who is present. He's also a member of the legislature, a member of the Judiciary Committee, also the lawyer of the day who is helping organize and facilitate these proceedings. Also recognize Doug Dumont, who is the assistant principal here today. And as always, recognizing the custodial staff, the AV setup. As I've said before, the auditorium setup, which was set by the Lewiston Blue Devils football team. As I said before, if their precision in their playmaking matches the precision they've set up here, they should be in good shape. So we're ready to get underway with this proceeding here today. Ordinarily, I would ask the attorneys to stand and indicate who they are representing, but given the numbers we're dealing with here today, I'll ask anyone who will be arguing here today, please give us your name at the outset, and we can save some time going forward. That being said, I believe we are in order to proceed. We'll call the case. This is Cumberland 24-82, Peter Masucci et al. Versus Judy's Moody, LLC et al. And you have prepared a list of presentations. We've coordinated with you. And I believe, Attorney Richard, you are first up. Is that correct?
That's correct, Your Honor.
All right. We'd be happy to hear your arguments then.
Keith Richard of Archipelago on behalf of the appellants Masucci et al. May it please the Court. This is a case to restore the public's rights on intertidal land. Bell versus Town of Wells was the first case in Maine history that held that public access for a particular purpose was prohibited. In every single prior decision, whenever the issue was whether someone had the right to cross over, enter, remain on intertidal land without taking or leaving anything, the court sided with the public over the private owner. Bell must be conclusively overruled now, not merely because it was wrong, but because it was jarringly out of step and anomaly at the time it was decided, and it's been criticized in each case since. Eaton, McGarvey, Ross have been incremental steps to correcting the error, all leading here. To end the acrimony, chaos, and conflict, we ask, legalize reasonable recreational use of the intertidal zone. We have presented the court with multiple grounds to get there. Recreation is legal, both because the common law allows it and because the legislature by statute said so, and in so doing did not commit an unconstitutional taking. That was a perfectly permissible exercise of the state's police power to say what the public trust is. Bell's holding otherwise was clearly wrong, but it appears to be the only reported precedential decision holding that a statute defining public trust rights was an unconstitutional taking. And if there's another case out there, appellees here haven't cited it. The state always has the power to define public trust, even if intertidal land can be privately owned. There is no such thing as unqualified fee title ownership of public trust land. And at bottom, we're asking the court to let other branches of government, let municipalities have a say. In taking a step back, this court can return to just deciding cases, whether a user is unreasonably interfering with a private owner's rights, rather than making policy. And it's worth emphasizing that our opponents in this case rely on per se, automatic rules, that a use is per se not allowed, that a shift in the law is per se a taking because they must. There's no good argument for their position if the court correctly applies the reasonableness or balancing standards that apply to those issues. Almost everyone believes in these public rights, and only a few of the very few who own waterfront property want to retain the right to exclude, and their view is extreme. They read Bell to give them a private beach, and their signs say so. We ask this court to fix this imbalance of public and private rights that Bell created. I'm ready for questions.
All right, we'll turn the green light on it. Just to get started, we have so much to talk about here today, not a whole lot of time. But I want to start off the conversation with the issue of justiciability standing. And as we know, some of the defendants put up signs. And I'll talk about the non-business plaintiffs here. Put up some signs, no loitering, etc. In order to have standing, there must be a live controversy. And it has been suggested that perhaps there isn't a live controversy because people continue to walk and traverse the intertidal area, and that the plaintiffs have ginned up standing by sort of created this controversy because they are now, their walking opportunities have been impacted by the fact that they're stressed out by the fact that it may result in a conflict. Is that enough to get past the gates of standing and justiciability?
That is a particularized injury, Your Honor. The trial court found that there was standing in this case because several plaintiffs are actual users of Moody Beach. They have seen the signs. The signs have affected their experience of accessing Moody Beach, which is a public resource as to the intertidal zone.
Have any of them actually trod upon the areas past the signs?
They have, and the summary judgment record reflects that.
And was there any conflict or concern or adverse effect to them if, in fact, they did that?
The summary judgment record, and I point Your Honors to the appendix at 837 to 859, and specifically to 838 to 843, establishes that the plaintiffs that the trial court found had standing have established a record that they have felt that.
So just to be clear, since you're on top of the record, so they walked onto the property and the beach owner said, they said to the beach owner, I want to do X on your property, and the beach owner said, no, you may not, get off my property. Is that the record?
The record is that the sign says that Moody Beach is a private beach to the low water mark.
Correct. And
So where
no
is it
loitering, correct?
Correct.
And they felt chilled by that, correct?
It doesn't say welcome fishers, fowlers, and navigators.
So they have standing as long as it doesn't say welcome?
Their injury is the adverse experience of accessing Moody Beach, and that their enjoyment of that area is affected by it negatively, and that they would otherwise engage in activities that they don't because of the chilling effect.
Well, I understand that there's one plaintiff, Gilbert, correct, who wanted to harvest rockweed, and he was rebuffed, correct?
As to the seaweed issues, I'm
right.
talking about Moody Beach.
Well, we'll get there. As to the seaweed issue, and so he was rebuffed, and that he tried to do something he didn't. He had standing. Here's something you'll disagree with, my hypo, but if he's the only one who had standing, can he argue all the claims, or is he limited to only arguing about rockweed? Because if we only have to find one person has standing, but they're able to argue absolutely everything, then we don't have to figure out which ones have standing and which don't.
I think Mr. Gilbert there is in the summary judgment record that he recreated on the intertidal zone. But as to that hypothetical, I would agree with you, Your Honor. But we do, as to the Moody Beach plaintiffs, have a record that establishes all these uses, specifically Peter Masucci, Kathy Masucci, and William Canerney, that raise recreation generally.
Can I ask you just a procedural question? Have the plaintiffs' counsel agree to divide up particular subject matters during your arguments, or is it fair game for all of it?
Fair game for all.
Okay.
All right, well, then I'll go on to another topic. When it comes to the issue of title ownership, okay, because you're making two basic arguments. One is they don't own it, and the other one is if they own it, they're subject to a sympathetically generous fish fouling and navigating, and broadly construed. So let's focus on ownership, title ownership. It's pretty clear in Bell that the ownership decision was made, and you say it was incorrectly made. How, if we agreed with you, how can we change the law after the Supreme Court's decision in Stop the Beach Renourishment, which says after a court has established title, if you take it away by a new decision, that's an unconstitutional taking under the U.S. Constitution?
Public trust land is different. Stop the Beach Nourishment is not a public trust case.
Why is that different?
Because public trust land is incapable of alienation by the state. It's always held in trust by the public, by the state.
Under what law?
Under U.S. Supreme Court law and under state law.
Well,
In order to give your clients the remedy they're seeking here, do we have to throw Bell in the dustbin?
Say that again?
In order to give your clients the relief they're looking for here, do we have to give Bell the heave-ho?
I think that Bell is hobbling and it deserves a proper burial.
Okay, all right.
Regarding standing, I take it your client's position is they want to be able to loiter, as the signs indicate, on the beach. And this would be analogous to a Fitzgerald plaintiff driving up to Baxter State Park and finding a sign saying no loitering, no camping, something of that nature, I take it.
So the issue of a public user of a publicly available resource and then whether the signage is a justiciable controversy, I see those as separate. The more recent case is Black, and in that case, unlike Fitzgerald, we were looking, it wasn't that the AG was disabled, they were actual users of the resource, and those arguments were made. I think signage is enough to make a justiciable controversy. There's over 400 pages of briefing that suggest that this controversy is very much a controversy. So I think that if the defendants if they agreed, okay, well, if you would like to engage in whatever recreational use there is, we don't object, we take down the signs, that's a different case.
Are your clients in the same circumstance as the plaintiffs in the Fitzgerald case?
Well, it's not about the Baxter State Trust and a breach of a trust document. We're more like the public lands in Black.
Okay, so you say Fitzgerald doesn't control?
I think that Black is the more analogous case. Fitzgerald is a foundational standing case in Maine, and it is about public access to a publicly available park, there, Baxter State Park. But I think Black is the more recent applicable authority.
Okay, all right. I'm going to do for you what I'm going to do, frankly, for everybody. I'm going to give you maybe 30 seconds. If there's something you wanted to say coming to the lectern that you weren't able to say, take 30 seconds.
I want to address the seaweed issue, Your Honor, because I think that with the benefit of the common law and of the statute from 1820, of the legislature's statement of DMR's regulation, there is no way that Ross can survive. And it is an example of why the common law system of making policy, when you don't have all the information, is not a good way to make policy.
Thank you.
Justice Meade, may I ask a question?
Certainly. I guess another question.
Sorry, Justice Douglas.
Thank you. You're making the argument here that the beachfront owners do not have title, that Bell was incorrectly decided. Is that right?
Correct.
And what's the basis for that? No, go ahead.
Bell misconstrued Article 10 of the Maine Constitution and misconstrued Lappish and all the cases that follow it to mean that Maine properly alienated title to intertidal land, when the U.S. Supreme Court in every case says that upon statehood, a state takes title to intertidal land.
How do you reconcile that position with the Eaton case and with the Almeida case? In both of those cases, title to a particular lot on the beach was traced back to essentially Charles I. So if it's the case that the Crown properly conveyed property to proprietors, and proprietors properly conveyed property, the interest in that property to an owner, and that deed chain carries all the way to the present, how is that not a property right? How is that not a vested right, regardless of the fact that the state of Maine came into existence in 1820?
Read the U.S. Supreme Court cases. Equal footing doctrine voids everything that came before it at state.
Well, what does the equal footing doctrine actually say? It says that the incoming state, the new states, take the rights of the original 13, right? They're on the same footing.
Correct.
But the original 13 weren't on the same footing. And Shively specifically recognized that Massachusetts was in a different place than Virginia or Delaware or North Carolina. And it specifically recognized that the Massachusetts law said that those property owners had a vested right in the property.
Massachusetts law cannot control another state's assumption of title pursuant to equal footing as a matter of federal constitutional law. Federal constitutional law is supreme to any parent state's property law or to any other principle.
But the Due Process Clause is also federal constitutional law. So how do you reconcile equal footing with the 14th and 5th
Because
Amendments?
it vests title in the government. You can't adversely possess property against the government. Property that goes to the government is different. It's not ordinary private property.
Thank you.
All right, thank you. Professor? And would you please state your name for the record?
It please the court, my name is Orlando DeLogue. I'm a plaintiff pro se in these proceedings. I would begin by simply saying that I have offered in brief 4 separate arguments asserting that Maine, not upland owners, hold title to its intertidal lands. Each argument repudiates the line of cases that begin with Storer, go through Lappish, Barrows, Bell 1, and Bell 2, and Ross. Count 1 notes that the Storer court misquoted the colonial ordinance. Misquoted. The ordinance says upland owners shall have property to low water. In the 16th and 17th century, this connoted a license, nothing more. It did not grant title. Storer and succeeding Maine cases erroneously treated the ordinance as a grant. In short, the foundational premise for the line of cases noted beginning with Lappish is incorrect. Maine holds title to its intertidal land. Count 2 recognizes that the Revolution, the founding of the Union, ushered in a new paradigm. Intertidal land laws enacted by Spanish, English, colonial bodies became a nullity. Maine's Statehood Act noted that it was admitted into the Union on an equal footing with the original states. The majority of the original states adopted English common law.
Can I challenge you on that? The equal footing doctrine, as Justice Douglas pointed out, does equal footing mean it adopts the majority of the state's practices? What if the state decided?
That seems to be what the Supreme Court has in its case law.
So they've said out loud that the equal footing means that if a majority of the original
in Shively, they acknowledge that Massachusetts beat a different drum, but that the majority of states had in fact obtained title. The Shively case itself involving Oregon clearly held that upon statehood, Oregon gained title to its intertidal land. A more recent case involving Montana held the same thing. Upon statehood, Montana gained title to
Now,
its...
after they became a state, the state has the power to then divest itself of title and give that aspects of its title to private property owners, correct?
Discrete parcels can be alienated by the legislature. There is a constitutional provision in Maine's Constitution dealing with separation of powers that makes clear that a judicial usage, that's what Storer created, a judicial usage. There was no legislation here that alienated the title.
Well, to be
Lappish
clear,
accepted a judicial usage, and so did all of the cases following Lappish.
but to be clear, the property owner can alienate, the property can be alienated, but it may be subject to certain public use rights, correct? You're not saying that the property can't be alienated except by the legislature.
I'm not sure I understand the question, Your Honor.
No, it probably wasn't clear. You're not saying,
That means try again.
try again, all right. You're not saying that that the property can't be alienated just because the legislature doesn't pass a law. It can be alienated, but subject to whatever public use rights might exist.
Well, intertidal land cannot be alienated by the judicial branch of government according to Maine's Constitution. The language is clear. The count 3 in my brief makes the argument that the Constitution posits that the judicial branch may not inveigh upon the prerogatives of either the legislative or executive branches. The line is clearly drawn. The language in Ex parte Davis, no person or persons belonging to one of these departments shall exercise any of the powers properly belonging to either of the others. To the extent that the title to intertidal land is said to have been alienated to the upland owners by a judicial usage is facially at odds with Maine's Constitution.
And I see that the red light is on, but I think Justice Horton had a question. And
Regarding the equal footing doctrine, you made the point that Oregon and Montana elected to exercise public rights over.
There are Supreme Court cases, Your Honor, that cover Georgia and Mississippi. The Phillips Petroleum case that was decided a year before Bell II, which was ignored by the Bell II court, clearly held. I'm sorry, sir.
Maine was obviously part of Massachusetts before Maine became a state. Were any of the other states, such as Oregon, Montana, Georgia, Mississippi, parts of other states before they became states?
No, Your Honor, not to my knowledge.
I mean, the argument is that once Massachusetts had established its position regarding the intertidal zone, that carried over to Maine because Maine emerged from the state of Massachusetts.
Massachusetts, in that status, though, does not have the prerogative under the equal footing doctrine to dictate the law of the emerging state of Maine. That is not equality, and there are Supreme Court case laws that state that more bluntly than I've tried to this afternoon.
I see your time is up, but I'll give you the same prerogative I'm giving the other parties. If there's something that you wanted to say and weren't able to during our questioning, I'll give you another 30 seconds or so if you want to wrap up.
I would simply say, beyond the 4 arguments I've offered in brief that assert ownership, if one or the other or the 4 arguments in combination do not persuade you that Maine is the owner of its intertidal lands, then I would certainly argue that the overturning of Part 2 of the Bell II case, which struck down the 1986 Act, which expanded public uses to include recreational usage, is out of step with Maine takings law. It's out of step with the U.S. Supreme Court's takings law. It is predicated on an error. The Bell II court assumed that upland owners could exclude the public, but even under the colonial ordinance, the public could not be excluded. They had fishing, fouling, and navigation rights. The 86 Act simply expanded those existing public rights to include recreational uses.
All right, thank you
Your
very
Honor.
much. And our next presenter? And would you please state your name for the record?
Yes, may it please the court, Assistant Attorney General Lauren Parker for Maine's Attorney General Aaron Fry, cross appellant.
So you have the green light instantly. Nobody gets saved time after this. So
Correct.
I'd like to, I know you spoke briefly about the Stop the Beach renourishment, but I tell you, I'm very concerned about how we can change our position, whether we agree or disagree about title. Once title has been declared in a case like Bell II, how does Stop the Beach not tell us that we can't change it without affecting a taking?
So I think there's two separate questions there. The impact of Stop the Beach renourishment on the fee question, so
Yes.
fee ownership, yes, and as compared with the scope of the public trust doctrine.
Right.
So I think the question is, would this court's decision erase an existing property right? And we have situations where, for example, OA 2012 has a judgment that say they own fee title to the low water mark. We also have a landscape, as Justice Douglas pointed out, where we adjudicate fee title on a property by property basis as opposed to sort of a sweeping all intertidal land at once. So I think the court is right to be concerned with a decision that would declare that all fee title, that fee title to intertidal land is owned by the state, when it's already declared in other instances that entities other than the state, like the town in Goose Rocks Beach or OA 2012, own to the low water mark.
Yeah, it would wipe all those out, right, if we take the plaintiff's position.
I think that it likely would, but the same concern doesn't present itself with respect to the common law public trust doctrine, because there you're asking, has it erased an established property right? So if you start from the standpoint of the intertidal land we know it's owned in certain instances by certain entities or presumed to be owned by private individuals. That ownership, regardless of who owns it, has always been subject to the common law public trust doctrine. So it is, the common law public trust doctrine are reserved rights. So when individuals, so the Maine's common law evolved to say that intertidal land in Maine is susceptible to private ownership, but always subject to the scope of the public trust doctrine. And so if this court were to author an opinion, which it should, that says the public trust doctrine in Maine includes walking, it's merely just delineating the existing limitations on
But in Bell,
title.
they said it didn't include recreational walking and it's like an easement, fish fouling and navigating. So once Bell has said the easement doesn't include this, doesn't Stop the Beach say you can't change your mind without affecting? Now it's not maybe a big taking because you're only expanding you're only trying to expand the use a little, but it's still changing ownership, usage, rights to include. Why isn't that a taking when you change what Bell said?
I think so. Two things in there. While the court has denominated the common law public trust doctrine as an easement, I think for sort of ease of reference, it is not an easement, and I think that is a critical point. Easement rights are acquired and passed along. Public trust rights are reserved. They were never handed out of the public domain. And because this is a function of the common law, which is adaptable, it can't be fully delineated and sort of frozen in time. And so Bell 2, the question before the court was there a general recreational easement in 1989? And this court decided, no, there's not. But here we have the narrow issue of what about just walking? And the court, when in 1989, Bell 2, was looking at walking as just an example of an entire universe of recreational rights.
What about we've said a number of times that beaches were used as highways in the colonial era. And there's recreational walking, and then there's what might be called purposeful walking, meaning walking to a destination. And we've talked in various cases about the right to pass over the intertidal zone to go to other people's property. Do we need to rely on the public trust doctrine in order to establish the right to pass over, not recreationally necessarily, but to walk along the beach to get from one place to another?
So I think, to take a sort of very narrow view, if the court felt that it was limited to fishing, fouling, and navigation only, I think because walking is, point-to-point movement, that it would be considered navigation as we understand that term. But I do think the court should look at this through the lens of the adaptable, evolving common law public trust doctrine.
And I see your time. I'm sorry, did you wish to inquire?
I do, yes. So that would be more or less the McGarvey approach, and which Ross also employed sort of in tandem with the more traditional approach. But my question is, based on Bell and all of our other precedent, the public use rights that we have recognized really reside in fishing, fouling, or navigating, don't they? I mean, even the Crown's rights at common law, the jus publicum under common law was limited to fishing and navigation. So I know you're advocating for a more generous and perhaps broader view, but is that something you think we have authority to just, well, we'd have to overrule Bell, wouldn't we? Bell said recreational walking was not included in those traditional rights.
I don't agree that you have to overrule Bell 2 to get there. I think, do I think that Bell 2 was wrong in that regard? Yes, but that was a moment in time. That was what is the scope of the public trust doctrine in 1989. And I think with respect to the terms that appear in the colonial ordinance that we're so used to, fishing, fouling, and navigation, I think that those are terms that, those were the focus
So we
of the
could
activities.
so you're saying no stop the beach problem if suddenly we decided that fish fouling and navigating included walking, lying around, rolling a beach, absolutely everything? That's how we get around stop the beach, by just saying fish fouling and navigating means everything you want to do on a beach?
I think that is not the best approach. That's why I think the best approach would be adopting the test that was modeled in Ross and exemplified in the Bell 2 dissent and the McGarvey concurrence of fishing, fouling, and navigation readily construed as compared with broadly construed. And then if not one of those three things, does the use or activity strike a reasonable balance between private rights and public rights?
I see your time is up, and I know Justice Horton has at least one last question.
As I sit here, I'm just wondering, the one solution to this hair-splitting problem about what was contemplated by the colonial ordinance and what the public trust document means is for the state to take the property. Are you aware of any movement in that direction?
I'm not aware of any movement in that direction, and I don't think that the state should have to take for the public rights that the public already has.
What it already owns, as you're saying. Sure.
Yes.
Okay, thank you.
May I have my wish list?
It's the rule of the day.
Thank you, Your
In
Honor.
all seriousness, this is a conversation that should not be artificially truncated. So if there's something that you wanted to say, unable to say because of the questioning, and you can say it briefly, please go right ahead.
We'll be brief. We would ask that the court's opinion on this matter clarify that the public trust rights in intertidal land are not technically an easement, acknowledge, as does 12 MRS 571, that the state is a trustee of public trust rights, and rehabilitate in part the Public Trust and Intertidal Lands Act, because if you look carefully at that, most of that is not unconstitutional, even if you are measuring it against Bell.
Thank you.
Thank you, Your Honor.
All right, and I guess we are shifting gears here, and Attorney Smith will be next on the lineup. Yes.
Good morning.
And would you please state your name for the record?
My name is Gordon Smith. I represent the 7 individuals who are the rockweed defendants in this matter. That is, they were sued either because they contacted Marine Patrol regarding the harvest of rockweed on their property without their permission, or in the case of the defendant Robin Seeley, she was sued solely because she's a rockweed conservation activist or advocate rather. And in both of those cases, with all of the rockweed defendants, they were acting in reliance on this court's unanimous decision from 2019 in Ross v. Acadian Sea Plants that the owner of the intertidal land has the right to either permit or deny others from harvesting rockweed on their property. Most of the intertidal landowners, most of the rockweed defendants were dismissed, or the claims against the rockweed defendants were dismissed under the state's anti-SLAPP statute. Now, the court properly made that dismissal because the rockweed defendants were sued based on their petitioning activity, either contacting Marine Patrol or by merely trying to publicize, in the case of Robin Seeley, the Ross holding that landowners had the right to permit or deny rockweed harvest. Now, we are cross-appealing because the Superior Court committed legal error when it denied our request for attorney's fees under the statute. The legal error was that the Superior Court imposed a malintent test. The Superior Court found that attorney's fees should not be awarded because it found that the plaintiffs had not initiated their suit with quote-unquote malintent. Now, there's no malintent standard or any concept related to malintent in the anti-SLAPP statute or in the cases interpreting it when the court has looked at what test to apply when determining attorney's fees. And what the court...
Anti-SLAPP... What's that? Oh, I'm sorry.
Yep.
Now, as the program... No, go ahead. This is protected time.
Thank you, Your Honor. The court has said the test for whether or not attorney's fees should be awarded is whether they would further the purposes of the statute, and the court has said the purposes of the anti-SLAPP statute are twofold. One, obviously to protect, to safeguard First Amendment petitioning, and two, to deter meritless litigation. And in this case, both of those factors are present. As the Superior Court found, the rockweed defendants were identified and sued based on their petitioning activity. And the two claims against the rockweed defendants, one, ownership of that apply to the rockweed defendants, ownership of intertidal land being held by the state, and that Ross should be overturned, are without merit. On the title issue, you have centuries of unbroken precedent without any dissent indicating that the intertidal land is subject to private ownership. And in Ross, you have all 7 justices applying the broadest test possible, the common law balancing test, and finding that under that test...
Let's assume that the calls to the Marine Patrol authorities or calls to law enforcement constitute petitioning activity. Were your clients sued because of their petition activity? In other words, were they sued for making groundless calls to Marine Patrol? I thought the claims against your client had to do with title and access to rockweed rather than...
The only landowners that were sued were the landowners that contacted Marine Patrol.
But that doesn't mean they were sued for contacting the police.
There was no other reason that was identified for them to be...
Their position that the rockweed harvesters can't harvest rockweed was why they were sued, as I
which is
understand it.
completely inconsistent with settled unanimous law court precedent in Ross.
Well, are you saying when anybody calls the police to enforce the law, that's petitioning activity?
Yes, it is. It is petitioning activity.
So if I call the police because you're trespassing on my property, and I bring a declaratory judgment action because to establish title, I get hit with anti-SLAPP attorney's fees?
Because you filed a lawsuit?
Because I called the police to have you removed from what I claim is my property?
The the court has held that petitioning activity includes calling law enforcement. The court has, that's a uncontroverted holding from the law court. So whether or not, so it's prima facie petitioning activity. Now,
and I see your time is up. You actually anticipated my early question, so that's covered. But if there's something that you wanted to say that you weren't able to say, and you can say something, you can say it briefly, you're welcome to have some additional time here.
thank you. I would just say that the Rockweed defendants' inclusion in this litigation should be viewed as separate from the questions the questions of recreational use that the court has signaled it is interested in revisiting. In Ross, it signaled that, but they should not be viewed as legitimate defendants who have to protect themselves and from suit or defend themselves in suit because of the plaintiff's unwillingness to accept a unanimous 5-year-old law court decision.
And I'll ask you a question. In your opinion, was the lawsuit frivolous?
It certainly borders on frivolous, yes, based on settled existing precedent.
Thank you.
Thank you.
Good morning, Your Honors.
Would you state your name, please?
Sure. May it please the court, my name's Emily Arvisu. I represent Ocean 503. The Moody Beach defendants have divvied up topics,
okay.
if that's
All right.
that's allowed.
What's your topic?
I'm focusing on the issues of standing and justiciability. So any decision issued by this court impacting Maine's 3,000 miles of coastline cannot be supported by the lack of justiciable controversy now before it. First, plaintiffs lack standing with respect to count 4 specifically because to date this court has never recognized standing of an individual as a plaintiff to assert public trust rights in the intertidal zone against an upland owner. Second, plaintiffs have not met their burden of establishing that a justiciable controversy exists, and this court's review of the legal correctness of defendants' action or inaction will not make any real-world difference to the plaintiffs. With respect to the issue of standing on count 4 specifically, this is a different scenario than many of the intertidal decisions that have come before. In those previous cases, they've been in the context of a quiet title action or a trespass action that was asserted by the beachfront owner. And in those cases, specifically in Bell 1, this court said that it's clear that an individual can assert the public trust rights as a defense to a trespass or quiet title action. But it's an open question of whether an individual person has the ability to assert affirmatively the public trust rights in the intertidal zone. So
are you suggesting that prerogative exists solely to the Attorney General, to the state?
Yeah, it's our position that, as this court laid out in Bell 1, the Attorney General has the duty and power to initiate actions for the
exclusive
protection.
power, did we say that they have the exclusive prerogative to assert the public rights?
Yes, we believe that the Attorney General should be the one who is asserting these claims on behalf of the public due to the nature of those rights. But setting that aside, if in the instance that the Attorney General is disabled from doing so because of, a conflict of interest or something, then perhaps an individual could do so, but it would have to be an individual who's an actual substantial user and with a direct injury. I think in this case, some of these plaintiffs, 3 of them have been on, Ocean 503's property specifically, but they haven't been injured.
Does the rockweed harvester have a particularized injury here?
Not with respect to the Moody Beach defendants. I can't speak to others.
The Attorney General is a party in interest to this proceeding. They are making an argument. Your position is in favor of public trust rights, but your position is if the individual plaintiffs don't have standing, then the Attorney General is disabled in this case from asserting that position?
Not necessarily that the Attorney General is disabled in this case, but the Attorney General did not file an answer to the complaint. The Attorney General has not asserted any cross claims at the lower level, and so they participated in briefing to an extent, but they didn't actually file any sort of response. And they didn't formally, at least, assert claims. And I think it's interesting as well that in this particular case, the Attorney General has chosen not to pursue the title claims and has very narrowly tailored count 4 to just walking, as opposed to, the entirety of general recreational rights that plaintiffs are seeking.
And your clients object to a just walking use right?
So our clients have never objected to walking in the past. They essentially were chosen because they, as many Moody Beach property owners, have signs on their property indicating that it's a private beach. And then during discovery, we learned that they were also chosen because their property is along a right-of-way, and the size of their house is substantial, which plaintiff said indicates that they're not there on a shoestring.
So is it your position, or your client's position, that they do not object to the public walking along the intertidal zone in front of, on their particular properties?
Yeah, they have never objected in the past, but I think the question of whether they personally object is they're cognizant of the fact that any decision here is going to have wide-reaching implications, and so I think understandably they're reluctant to take a position that differs from current case law.
But as far as their property is concerned, they're not objecting?
They have never objected in the past, no.
The plaintiffs, if I may.
Yes, and then Justice Connors.
The plaintiffs seem to interpret the sign
Microphone.
as limiting, as prohibiting walking. Should the sign say no loitering, but walking is okay?
Well, I think this was actually explored during deposition of our client, Ocean 503, and they talked about the fact that no loitering, implies that you're just kind of standing there for an extended period of time, not really doing anything. And so, I think that would exclude walking from that definition.
Just a fact check. You said that 3 of the plaintiffs came onto the property of your defendants, correct?
Yeah, yes. So 3 of the plaintiffs have definitively come onto the Ocean 503 property.
And were they chased off? What happened?
No, ma'am. They have never interacted with our clients, to the best of my knowledge. There's been no confrontation, no objection, no action at all.
I see your time is up, but following the ad hoc process we're following, if there's something that you wanted to say, weren't able to say, if you can summarize that briefly, you're welcome to do so.
Thank you. Yes, I just want to reiterate again, given the weight of this court's decision and its potential impact on the entire coastline of the state of Maine, I think this court should give significant consideration to the standing issues and the lack of justiciability here. So I thank you for your time.
Thank you.
Good morning, Your Honors. Chris Keyser for Judy's Moody, and I'm going to focus on the title and use issues. And in view of that, I do want to focus mostly on the implications of what appellants are asking this court to do here. They ask this court essentially to transform, or to give the legislature the power to transform, what has always been or recognized as private property into public property. And they ask this court to do so without providing just compensation, as the constitutions of the United States and Maine require. As we've already discussed, private ownership of intertidal land in Maine is deeply rooted. It's been part of the common law in the state since before statehood. And while it's true that the law has always recognized some public rights in this area dating back to the colonial ordinance, this court has always noted, even it is incorrect to say that Bell II was the first time that the court limited these public rights. There are several 19th century cases, such as Deering and Marshall, where the court discussed that the rights of fishing and navigation were the ones that were specifically protected for public use. And just because that Bell II was the first case where actually the court had to deal with a larger claim due to the 1986 act, that was the first time that the court had to address the limits of fishing, fouling, and navigation. But it was not the first time.
I'd like to ask you a question about the intersection between this case, which focuses on the public rights conferred by the colonial ordinance and also the public trust doctrine, and the Almeida case, where we decided that in order to claim title to the intertidal zone, a beachfront property owner had to prove that their chain of title included title to low water. Has that been established for any of the appellees in this case? And if not, do they even have standing to assert the colonial ordinance?
Your Honor, in Bell II itself, this court actually held that title to Moody Beach for the Moody Beach owners goes down to the low water mark. So as for Moody Beach specifically, there's no dispute that title goes down to the low water mark here. So in my client and the other Moody defendants, they own title down to the low water mark under this court's current law.
Do you have any thoughts about others, though? People who aren't on Moody Beach and therefore aren't benefited by the Bell II judgment?
I think that's one of the problems with this court making a sweeping decision in this case when there's only 3 beach defendants here, because if this court were to say overrule Bell and overrule Lappish and say that the state holds title up to the high water mark, that would affect thousands of property owners across the state who aren't here to defend their rights, and it would do so without compensation. There would be no method in which this court actually, in the context of this case where we only have 3 Moody defendants here, to determine what kind of compensation should be given to those people who have these rights that have been recognized.
So if there's only one person literally left standing, the decision in the case would affect the entire coastline of Maine.
And yes, Your Honor, and that's the reason why, one of the reasons why this case is a poor vehicle to even to address, even if I agreed that Bell II was wrong, which I don't. This case would be
just about to ask you. We've heard arguments here today that Bell II just wrong, throw it away, throw it out. Can we do that? Should we do that?
No, you shouldn't do that. I think the biggest thing I would say is that Bell II doesn't stand on its own. Bell II was a case that simply synthesized the existing common law in this state and in Massachusetts going back to Storer. So to toss aside Bell II would inevitably affect a taking, because there are deeply rooted rights here, private title down to the low water mark, that are subject only to the limitations that the common law has recognized, which are fishing.
Did Bell II announce what the common law is?
Your Honor, yes. Bell II synthesized the prior case law, including cases like Deering, Marshall, and Andrews, and it declared that fishing, fouling, and navigation, a liberal construction of those were that was the limit of, and this is consistent with Massachusetts in the opinion of the justices, advisory opinion that the Massachusetts Supreme Judicial Court issued in 1974. So when my friend on the other side said that there were no cases that said that a legislative conveyance in the public trust affected a taking, that's exactly what the Massachusetts Supreme Judicial Court found. And I realize it was
I think Justice Douglas has a question for you.
You may have just answered it. My question was, the plaintiffs aren't, at least the Attorney General's office is not asking for such a drastic remedy. They're not asking to disentitle anyone. They're just asking to expand a little bit the current public use rights. You view that as a taking?
Yes, Your Honor. The problem is that in Bell 2, the court said recreational walking.
I understand that. But if that were to be changed, if the court were to sort of change direction on that, is it your position that that's a taking under Stop the Beach or any other provision?
Yes, Your Honor. So actually, just this past term in Sheets versus El Dorado County, the United States Supreme Court adopted the plurality opinion in Stop the Beach and made it clear that any branch of government can affect a taking. And so when a judicial decision does expand public rights at the expense of previously recognized private rights, that would be a taking, and the amount of the taking that just goes to the amount of compensation. So, for instance, in the U.S. Supreme Court's case of Cedar Point in 2021, in that case it was just the right to exclude for 3 hours per day, 120 days per year, and I believe at oral argument in that case, Justice Barrett noted that the potential compensation might be something like $50. But the court still held that it was a taking because the scope of it, whether it's just adding walking, that might go to the compensation, but it doesn't go to the fact that there's an established right here that were the court to overrule Bell 2 on this ground would take that established right away without compensation.
So if Bell 2 were not overruled and were held, the legislature would have the option to expand the public use rights by eminent domain.
That's correct. There is a political solution here. I believe that was mentioned earlier as well. The state or the town of Wells could buy the land or condemn it through eminent domain.
In fact, some beach communities have done that.
And that's exactly what has happened in other towns. And so that's the solution, is that if the state wants there to be, or if the town of Wells wants there to be a public beach along Moody Beach, they can have that. They just have to pay for it under eminent domain. And that's the whole purpose of the Fifth Amendment.
All right. Do you have any, we're well into overtime, do you have any last words you wish to say?
I would simply urge this court to stick with the course that it's been on since Lappish, and recognize that these private rights are deeply rooted, and that to alter them at this time without compensating the landowners would be a taking in violation of the Fifth Amendment. Thank you.
Thank you.
Good afternoon, members of the court. I'm David Silk. I'm here with Sidney Thaxter, who was from Curtis Thaxter. He was lead counsel in Bell 1 and Bell 2. And I covered a lot of ground in my brief, why we don't believe there's a case or controversy before the court, lack of standing. The same signs that they point to as creating a chilling impact were the same signs that were the subject of the trial testimony in Bell 2. And without waiving the arguments on our brief, I just want to take a step back and talk a little bit about the issue whether this should be viewed as an easement, which is what both the Bell 1 and Bell 2 court said it should be viewed as. And for the most part, a majority of the justices, all 18 that have heard this case, counting the justices on Bell 2, majority of them viewed this as an easement versus viewing it under the lens of somehow it's a public trust where the fee is owned by the state and held in trust for the benefit of the people. The dichotomy, the easement language was codified, not codified, but was examined in Bell 1. And the reason for that was it was a quiet title action. And in Bell 1, the state took the position in the town that the plaintiffs couldn't even seek a quiet title because the state held the public rights and there was sovereign immunity. And if you read Bell 1, the unanimous opinion of the court, they went back in time, looked at the cases and said, we viewed this as an easement. The state doesn't own the fee to the intertidal zone. It's assuming you have a conveyance that gets you to the ocean. Historically, for 250 years, it's private property. And we've always viewed the rights reserved to the public as easements. And they cited the Manchester City Augusta case and other cases that say it's not uncommon where public easements are granted for the benefit of the public over private property. So that was the paradigm in Bell 1. Goes to trial, 16-day trial, 70 witnesses. Justice Broderick heard the case. And he viewed it as the instructions from the law court is examine this as you would in the context of a public easement. He heard the case, heard all the witnesses, and one thing I just want to share, he issued a 58-page decision. Again, this is a quiet title action, quiet title. Notice was given to the world, publication in the newspaper, guardians ad litem were appointed for people who couldn't appear or didn't appear. He said the public's need for recreation is important, but private rights are also important. Private property rights should be predictable and not subject to dramatic transformation by the courts when there is an absence of the traditional types of evidence that would normally justify the evolution of a common law doctrine. And that's the trial judge hearing this in the context of expanding whether liberally construed the rights reserved under the easement should include public recreational rights. You then have read Bell 2. I don't need to go there. You've read the concurrences and the subsequent cases. But I thought it'd be helpful for the court to understand how it came to be the court examined this. Again, they cited cases where they've done so in the past where they used the word easement, so it wasn't like they're inventing it out of whole cloth. But to overrule Bell 2, you would effectively have to overrule Bell 1.
I don't disagree with your characterization of Bell 1 at all, but if it was an easement case and if the court's decision depended on the evidence presented is, what's the res judicata effect of that decision?
I'm not sure
to what extent is the outcome of a quiet title action binding on parties to an easement beyond the parties to the litigation?
In terms of this case?
At all, in general?
Well, at the end of the day, I think that, again, you've got a whole host of different judicial opinions by your colleagues going. That's why I said there are 18 justices that have heard this. I can't articulate any better than the views of those justices who believe Bell 2 should stand.
So if there had been a private litigation between private parties, obviously that's res judicata regarding those parties, but if the court makes a broad announcement of law that controls the decision there, is that res judicata for the entire world? Well, that broad statement of law.
Yeah. I mean, I think that was articulated in Bell 1 in terms of the nature of the scope of the easement that was reserved.
Okay. Yep, go.
So the state was saying that at times it's been treated like an easement, but because it relates to the public trust, there should be more room for the state to allow it to evolve. What's your response to that?
Well, again, my client stands in the position of res judicata in a quiet title action, and the position of the state would render res judicata meaningless because the state's position is that in 1989, the law court couldn't decide what would be their decision in 2024. They could only decide what their decision is as of 1989. And again, Chief Justice McHugh emphasized that the rights reserved should be liberally construed, sympathetically construed. There was an element clearly recognized by the majority in Bell 2 that this was an evolutionary process. It wasn't stuck in stone. And the question is, how far do you go? Where do you go? And again, that's the predicament the court addressed in Bell 2 with the the dissent and the majority. I can't, my view is, I think Justice Levy's concurrence and Justice Broderick's authorization is that we're not alone. Massachusetts has a tradition. Massachusetts' tradition is firm, that the public rights that reserved under the ordinance of what had been articulated in Bell 2.
I'll just step in for a second and ask if colleagues have
A quick question, if I might. Have your clients ever objected to anyone walking across the beach?
And again, in this record, in Bell 2, in Almadea, and in this record, there's never been an instant. Again, we have to differentiate between the dry sand and wet sand, Your Honor.
I'm talking about the intertidal
I know,
zone, yes.
but sometimes it gets confusing because usually there's a seawall, dry sand and wet sand. But on the wet sand, and I'll tell you why there's never been an objection. Most property owners own 50 feet of wet sand. I mean, there was adjudication in Bell 2, quiet title judgment. My client owns to the low water mark, owns. I mean, there's an adjudication, it's of record. But as soon as my client leaves the 50-foot and walks to the left and walks down someone else's intertidal zone, everyone recognizes that it's in their interest to give implied permission for everyone to walk up and down the beach. And so thousands and thousands every day, which is what Chief Justice McCusick recognized in Bell 2, was mentioned in Almadea, uninterrupted, people walk the beach. It's a Maine tradition. It's a Maine allowance. And I understand the pro se DeLogue's issue is with the court's jurisprudence. He's never, ever been interfered with in any way walking up and down the beach. It's like hunting on posted land.
Justice Douglas, did you have any further follow-up? All right. Thank you very much. Okay, we're back to rebuttal.
Yes.
And I'm not sure if I'll continue the ad hoc last words thing, so if there's something you want to get your last words in, you'd want to do it within your allotted time.
Okay. Thank you, Your Honor. I just want to first start with stop the beach nourishment, because I think the takings question is a fair question. Look at the cases. In all of the cases that are cited where there's been a taking, the owner had a fee simple absolute ownership, no easement, no public trust right. That's why it's distinguishable. Look at Phillips Petroleum. The state has the authority to define its public trust law. What can that mean if any time the state defines its public trust law, it commits a taking? And the more recent case than Stop the Beach is Cedar Point. In Cedar Point, decided in 2021, the court states very clearly that property open to the public is readily distinguishable from regulations granting a right to invade property close to the public. The intertitle is open to the public. It's readily distinguishable from private property that is within the takings jurisprudence.
Going once, going twice?
There don't seem to be any, doesn't seem to be any conflict here, though, in the sense that I haven't heard from any of the property owners that there's an objection to the public walking through the intertidal zone.
The signage and the chilling effect is, it overstates their rights. That misstates, even under Bell, private beach, no loitering, I think is as construed in the summary judgment record, is a misstatement, an overstatement of their rights. And there's enough for a justiciable controversy.
How is it an overstatement if they own it? I mean, you don't like that they owned it, but I mean, is that enough to give you standing? You just don't like the fact that they say they own it?
How would a reasonable person interpret a sign that says private beach?
It says no loitering, so doesn't that mean if you don't loiter, okay, and they've never stopped you? So how is there a real case or controversy?
Some people might view fishing as loitering.
Right. Well, what is loitering? Is it loitering by the sign? How long do I have to loiter? If walking's okay, how can I remain? There is enough to get into court on this controversy because of, and look at the cases on standing and justiciable controversies. It's whether it has an impact on the plaintiff that's sufficient to create an injury. And we've established a record here on summary judgment for that. If I could go back to the question around whether there was ever a state that became a state out of another's common law, that would be Pollard versus Hagan, where Alabama came out of Georgia. We cite that in our briefing.
But with respect to that doctrine,
sure.
Precisely what is the holding in Shively? what, is it that any new state coming into the Union comes in on equal footing with the majority of other states?
So it comes in on equal footing, which means title ownership of intertidal lands.
But that wasn't the state of the law in Massachusetts.
Right, well, but Massachusetts law, for Massachusetts law to control Maine would be that Maine is unequal. It would come into the Union on unequal footing because we happen to be related to Massachusetts, which is contrary to federal law.
So your argument is Maine had to come in on equal footing with the majority of other states?
Every state that was admitted to the Union subsequent to the original 13 took title to intertidal land, period. That's what the Supreme Court has said in every case. And on the anti-SLAPP, the standard is whether the claims are based on the petitioning activity. So there's no question that a phone call to the police has been held to be petitioning activity, but the claims are not based on that petitioning activity. There is a controversy with respect to seaweed that I think has been established in this record.
You have 45 seconds.
The upland owners, they're not objecting to the walking or to the uses by the plaintiffs, but what they want is the right to object. They want the right to post the sign. They want the right to claim the ability to do so. And that is enough to create a controversy because there's a disagreement about the parties' respective rights. Okay.
All right, you've had the last word.
Thank you.
For your side.
Thank you, Justice. We very much appreciate the extended time and I appreciate the opportunity.
Okay, thank you.
Thank you, Gordon Smith again. Following up on that discussion that we just had with Justice Douglas, asking what does the equal footing doctrine mean when some of the original states had already conveyed out their intertidal land. And it doesn't mean, the equal footing doctrine does not say, and the Supreme Court has not said, that it means that all states gain title, whatever the state of the title was before statehood, when they enter into become a state, that all of a sudden the records are wiped clear and the state owns all the intertidal land. What the equal footing doctrine says is that the newly admitted states have the same rights as the original states. And that right includes the right to convey that land, among other rights. And it's instructive to read from Phillips Petroleum, and quoting Shively v. Bowlby, it says, Phillips Petroleum's quoting Shively v. Bowlby and says, "There is no universal and uniform law upon the subject, but each state has dealt with the lands under the tidewaters within its borders according to its own views of justice and policy. Many coastal states, as a matter of state law, granted all or a portion of their tidelands to adjacent upland property owners long ago. Our decision today does nothing to change ownership rights in states which previously relinquished a public trust claim to tidelands such as those at issue here." So the Supreme Court has recognized that there is no universal vesting of title in the state. The states have the authority to determine what rights they want to convey or retain in the intertidal. And Maine, in the adoption of its constitution, said, we are, in Article 10, said, we are adopting the common law of Massachusetts, so as long as it's not repugnant to some other part of our constitution. So that was a foundational act of the Maine, the people of Maine in adopting that constitution. That was an affirmative act in which they adopted Massachusetts.
Should the Maine legislature have taken that step instead of the courts? In other words,
I don't think the courts did.
The plaintiffs are making a separation of powers argument, I believe, or at least they at one point.
Yeah, no, it's not. The courts have not. The courts are interpreting the colonial ordinance of 1647. They're also interpreting the common law of Massachusetts. They're interpreting the Constitution of Maine and subsequent case law that has unanimously held that in Massachusetts and in Maine, the states have decided, either through the colonial ordinance and usage or through the adoption of the Maine Constitution, that intertidal land in these states, among others, by the way, is susceptible to private ownership. we heard that, that somehow the Maine law court misquoted, or rather, it wasn't the Maine court, it was the Massachusetts Supreme Judicial Court in Storer misquoted the colonial ordinance by saying that property that the upland owner holds down to the low water. That wasn't a quote. The court in Storer was not quoting the colonial ordinance. It was interpreting the colonial ordinance. What does that word propriety mean? And in the early 1800s, closer in time to when the colonial ordinance was adopted, that was the understanding of the court at that time, is when that was a grant of property or propriety, that meant that you hold down to the low water. We heard about the chilling effect that the signs supposedly have on the people who walk on Moody Beach. Taking that into the context of the anti-SLAPP dismissal, the question was this petitioning activity, and if so, are the plaintiff's claims based on that petitioning activity? We also have to view this in terms of the chilling effect that the plaintiff's suit against the Rockweed defendants for simply following the court's guidance in Ross will have on those defendants and other landowners, where the only landowners that were sued were the ones that contacted contacted Marine Patrol, or in the case of Robin Seeley, there are no allegations against her other than she's publicizing the rights that landowners have under Ross.
Thank you.
Thank you very much.
All right, that concludes our oral arguments in these matters. The court thanks counsel for your thoughtful arguments and your excellent briefs. You all did a terrific job in briefing these complex issues. We appreciate it. Rest assured, we've read them in detail. We'll read them again. It's clear that the case may have very consequential results. No one knows at this point. So we'll take the matter under advisement, issue a decision in due course. And for the students and anybody else who may be wondering, what that means is that the 6 of us will meet behind closed doors and debate it amongst ourselves. If we all agree on a single result for each of the varying claims, we would issue what's called a unanimous opinion, which I don't think we've done yet in this proceedings. Have we done that? I guess the original Bell one was unanimous. If we don't, justices have the right to issue a dissent saying, well, I see it a little bit differently. But we'll have to wait till we issue the decision in due course. Again, many thanks to counsel for your excellent materials in this. And this court stands in recess until our next term.